Well, the statistics are in. Studies show 1 out of 1 of us is going to die. How are you preparing? Let's talk about it. All right, here we go, guys. So what in the world are we going to do? All of us are heading for the grave, and we got to prepare. None of us like to talk about it. None of us like to think about it. And especially folks mine and Colin's age, I mean, it seems like that's the last thing we want to think about. But today on Suits and Boots Legal Talk, we're going to talk about it. And we want you to hear it because it's important for us to plan for this. So I'm Luke Martin. This is Colin Funk, David Bimbo. We're all at Bimbo, Davidson, and Martin Attorneys there. And today we want to talk about how do we plan for this and what do we need to do. I have people tell me all the time, Luke, I'm glad you're an attorney. I'm glad your business is doing well or whatever, but I'm glad I don't ever need you. And really, when we think about it, and one of the things I tell them is that's not true. You need to have an attorney, whether it's one of us or some other attorney. You need to do this estate planning is what we call it. Planning for the time that you die and how are these assets going to be handled. And so let's just talk about it. So we know, and what we typically tell people is there's at least 3, maybe 4 documents that everybody needs. David, what's the first document that you would say someone would need?
Well, I really think that I have seen more people helped with a general power of attorney, because if mom or dad become incompetent, that general power of attorney can be used to continue handling mom or dad's affairs, as far as signing mom or dad's name.
Yeah.
It doesn't give a person the guardianship or anything like that, but most of the things that mom and dad deal with can be dealt with through a general durable power of attorney.
And as we talked about in another podcast, if you want to do a 1% deed or something like that for Medicaid planning, you can use this general power of attorney if it's drafted correctly to do that. And so it's really important that we get to look at that general power of attorney. Especially, I do a lot of real estate. That's mostly what I do for the practice. And especially for real estate transactions, those powers of attorney have to be drafted correctly or we can really run into some problems. Colin, what's another document that people should consider having?
Yeah, I'd say the big one as far as estate planning would be your will. Your will is kind of your instructions for where you want things to go when you pass away and who you want to kind of manage your estate when you pass away. Yeah.
So, and David, a healthcare power of attorney. I know people have talked about that, and I get a lot of confusion about. Well, I've got a power of attorney, so I'm good to take care of mom on everything she needs. But that's not necessarily true, right?
That's correct. A healthcare power of attorney gives someone the right to make healthcare decisions for a person if that person becomes incompetent. And so you would have a right to say who you want to make those healthcare decisions for you. It's especially important if you've got a blended family, if you've got a wayward child. You don't want that son from California that you haven't seen in 7 years to show up making healthcare decisions.
No offense against California, right?
No, I meant it. I said what I meant. and I've seen it, and I've been practicing law a long time, and I've seen the healthcare power of attorney and a general durable power of attorney usually keeps people from having to have someone declared incompetent through a court procedure if they don't have these documents.
Yeah, so let's say you don't have a general power of attorney. We see this quite a bit, and you and I have helped folks through this often. There's no general power of attorney, and there's an awful car accident or something like that, or dementia sets in and they've waited too long. How do we take care of those folks' affairs who aren't able to do it themselves if they don't have a power of attorney?
Sometimes it's necessary to file a guardianship proceeding, have a hearing before the clerk of court. A guardian ad litem would be appointed for the person, and the guardian ad litem would visit with the person and satisfy himself or herself, it's a lawyer, of whether the person is competent or not. And there would be a doctor involved, and there'd be a hearing. And people would testify, yes, I think he or she's competent, or he or she's not competent. And it's an expensive procedure, which usually can be avoided if you've already got a power of attorney, a general durable power of attorney in place, and a healthcare power of attorney. there are two. There's a guardian of the estate and a guardian of the person that's appointed. The guardian of the estate looks after the incompetent person's finances and bills and so forth, and the guardian of the person looks after where do they live, what can the doctor do this surgery, or who signs for the surgery.
It's kind of a mirror of that power of attorney and healthcare power of attorney.
It is, but it
in a
involves
guardianship.
the court,
Yeah.
and you'll have to have annual reportings done if you're a guardian, and rightly so.
Sure.
Many times there are guardians appointed for children that are hurt in an accident, automobile accident or something like that.
Yeah.
And that can usually be a parent, but not always.
So I kind of touched on this earlier. This is something that older people need to worry about, or younger people need to worry about, or who needs a power of attorney?
It depends, because we can't predict the future.
That's right.
And I remember, well, I won't go into that one, but it's not a real expensive proposition, and if it's needed, it's worth its weight in gold.
That's it. And we don't know when someone's going to cross that yellow line, or when someone's going to merge into us. And it doesn't matter whether you're 20 or whether you're 80.
Yeah.
That can be that bad things can happen, right? And those powers of attorney really make it easier.
Yeah, and especially if you're married and have children, or you're buying your first home or something of that nature, you definitely need them. If you're you got a family, got children, and buying real estate, you definitely need these things.
Folks are a lot of times nervous, Colin, about giving someone the power of attorney, the power that comes with that. There are things that we can do to delay the effectiveness of that power of attorney, or if they don't want to give that person the power now, maybe they say, hey, I only want them to be able to use this power of attorney if I'm unable to do it myself. We can set that up, right?
Yeah, absolutely. It's not unfettered control you're given to this person. There's ways we can kind of reel in, even what they can do when they do need it. One of the things that comes to mind with healthcare powers of attorney, there's things where we can put it in there as far as preserving you on life support and stuff like that, to where you can put limitations in your document that says, I only want them to have the power to withhold this kind of artificial nutrition or hydration if XYZ happens. So we can kind of make it as broad or as narrow as you want to for your planning, for whatever purposes you see necessary to, make sure that, if it's someone that you just need to get this done for a very specific purpose, then we can make it narrow. Or if it's to your spouse and you have, absolute trust in them, make it as broad as possible, just knowing that they have your best interest in mind.
And for real estate, we do these things called limited powers of attorney all the time. And sometimes we'll make someone a power of attorney who's not even related to the person, just to handle the real estate transaction. So if you do have someone that lives in California, but they own real property in North Carolina and they don't want to come here to closing, but they want somebody here to represent their interest, we can do a limited power of attorney that says, hey, just for the duration of this process, I want to appoint this person to take care of signing for me.
And usually when a person is in the military and being deployed, usually the JAG officers will do a whole lot of powers of attorney and healthcare powers of attorney and wills. But sometimes folks that are deployed don't have time to get to the JAG officer in the Army or whatever, and they can come to us, and we're very military friendly at our law firm, and
absolutely.
Our firm has done many of those when somebody's getting ready to deploy.
Yep. And so powers of attorney, healthcare power of attorney. Healthcare power of attorney gives people the power to do healthcare decisions. General durable power of attorney just makes business decisions, basically.
Yeah, it's pretty much controlling anything legally or financially that you'd be able to control yourself. And that durable language that we talk about there is basically, you need to have capacity when you execute the document. You need to know what you're doing when you initially sign that document. But once it's signed, that durable language says that no matter what happens to you, as long as you're still alive, that person that you name as your power of attorney is going to be able to make those decisions for you.
And what you said right there is really important, because I've had folks call me and say, hey, my brother passed away or my mom passed away and I'm his power of attorney. And I always have to say, well, not anymore, you're not. Talk a little bit about that.
Yeah, so a power of attorney is really just good for the life of the person who's executing the document. After they've passed away, a lot of people think that, I guess, an executor and a power of attorney are kind of synonymous, and they're not. Power of attorney is just good for the life of the person executing the document.
And so at that point, you mentioned a will. So at that point, a will takes over. Talk about what a will is and maybe the components of it and how it works versus the power of attorney.
Yeah, so at the baseline, a will it's kind of just a piece of paper until you pass away. It's kind of the opposite of the power of attorney in that way, to where power of attorney stops at your death and a will kind of springs to life when you pass away. So a will can kind of be broken down into the, saying who you are, saying what you own, saying, you don't have to say what you own, but saying who is going to get the stuff that is yours. And if you don't have specifics in mind, there's clauses that we can put in there to kind of just say whatever I own at the time of my death goes to these people or my spouse. So basically who you are, who you want your things to go to, and who you want to manage your affairs, or be your executor when you pass away. And that's the person who's going to, potentially have to work with the clerk of court. And, if it's a good estate plan and that's what's best for you, potentially not have to go to the clerk of court and do an estate for you.
Yeah,
so it's kind of the instructions for where your stuff's going to go and how you want it to be done. And
one of the things we talked about was guardians. And guardians of the estate, guardians of the person, those kind of complicated things. A few years ago, we had this big internet uproar about Free Britney because of this conservatorship that she had. And whenever we have minors whose parents have died, this maybe wasn't exactly the Britney Spears thing, but when parents die, we end up with a conservatorship in the court system. And so that's why for young families, if you have minor children, you need a will more than anybody else in the world. Wouldn't you agree, Colin?
Yeah, it's it really is the difference between your who's going to look after your loved ones and who's going to get your stuff. What's really important is making sure that your loved ones are taken care of. It's your young children. If they're under 18 when you pass away, they can't take your stuff. They're not legally allowed to own your property or anything like that. So we need to kind of set up a plan in place to appoint someone who is going to be able to have their best interest in mind. We can do that through a guardianship, and then there's also trusts, a testamentary trust that we can put into a will, and we'll get into that in a little bit. But yeah, that's really when it's most important, just to make sure that your loved ones are taken care of, and the assets that you have left behind can be used for their benefit.
And so, David, whenever we do these wills for folks with minor children, they get to nominate a guardian for those children, right?
They can suggest a custodian. And the custodian is the person with whom the children would live. Of course, that's subject. I always use my brother John as an example. If I had my brother John down as the custodian for my children, my brother John is a retired pediatrician over in Concord. And if John said, I don't want to do it, or I can't do it, or if John got convicted of a felony or something of that nature, the court would not allow John to have custody, just like in a regular custody case.
Sure.
But most of the time, you're not going to pick somebody that's not going to be able to do it, or not willing to do it, or has been convicted of felonies and that sort of thing. A guardian, as you ask, is the person that looks after the children's finances, has the ability to pay money for the child to go to college, or for the child until the child's 18, I should say, to buy a car for the child or not. It's up to the guardian. And the guardian can be the same person as a custodian. Usually that's the best. But sometimes I've seen a situation where one brother is really good with finances, say he's a banker, and then the sister's really good at nurturing children. And so they
Sure.
work together,
Sure.
and you have one guardian and another custodian. And then I usually, and Colin will talk about this, but I usually recommend a simple trust where there are children involved. And because I usually recommend that the parents tie up the children's funds until they're at least 22, which usually gives them 4 years of college. And the simple trust could be as simple as for the health, education, and welfare of my child, or
Sure.
these children.
Sure.
And then the trustee of the trust would have the total discretion, if it's worded correctly, to let little Johnny have an inexpensive Prius to drive to and from UNCC for college, or say no to little Johnny when little Johnny wants a brand new Corvette to drive to college, just like a parent
Sure,
could.
sure.
And so that's something that I usually talk with parents about.
Yeah, and that time frame, I've always thought that was very wise, because that's something you've taught me from early on is, you know, you could terminate the trust when the child turns 18,
Yeah.
but then you may be dumping
Yeah.
thousands of dollars in a 18-year-old's lap, and
Right.
maybe that's not the best
Right.
idea.
And sometimes 22 is not the best idea.
Sometimes, yeah.
For
sometimes.
example, if you've got 3 children and one reaches 22 first, and you've provided for that child's college through that trust, you don't want that 22-year-old child to get his or her 1/3, because the others need to go to college too, and there needs to be adequate funds for that.
Sure.
You want to treat now that's what I recommend. I mean, but it's up to the client. But that's something to think about. And so that in that scenario, I usually recommend that the trust not terminate until the youngest surviving child reaches age 22.
Sure. Yeah, yeah, and that way you've got enough funds in there to take care of all of them
That's
until they get through. Maybe they can get established in their careers
That's right.
and get going.
And you can stagger the ages. If 22 get some funds to help them buy a car if they just graduate from college, and then age 25 when they'll be older and wiser, or age 30, whatever.
Well, and that's one reason it's so important to give that trustee discretion.
Yeah.
Because they can always do those things.
Life happens.
Exactly,
Yeah.
exactly. And it's also important to have a trustee, pun intended, that you can trust.
Yes.
Somebody that is wise and will make really good decisions for those children.
And I think that kind of the function of a trust is you are transferring the assets to the trustee. You know, the trustee kind of puts their trustee hat on. They're not acting in their personal capacity. They're the trustee. The trustee is the person who owns those assets, and they're just directed by you to use those assets in a specific way. So it's not that you're giving it to your kids. You're giving it to the trustee with instructions that they're bound to follow of how they need to, number one, use it for the term of the trust, and then at termination, who they need to distribute it to if there's anything left.
We lawyers are taught, and by experience mainly, to think of what's the worst case scenario. And that's where we see a lot of clients that come in, the worst case scenario has happened.
Exactly.
And so in planning any document, whether it's a contract to buy or sell real estate, whether it's a business partnership, whether it's a will, trust, you've got to think, what's the worst case scenario? Worst case scenario about a trust would be if the trustee starts misappropriating funds. Well, that trustee can be removed. If the trustee has posted a bond, then the bond can reimburse the funds. It's the same thing with guardianship, or frankly, if you've given a power of attorney, and I've seen this happen, somebody gives a power of attorney to a child, and the child starts misusing funds, then if the person's still competent, the person can remove that power of attorney by just revoking it.
Well, and one thing that we've talked around just a little bit here, but there's a big word that we use in the law called fiduciary responsibility. And when we're talking about an executor, or we're talking about a power of attorney, or we're talking about a trustee, they have what's called a fiduciary responsibility. What does that mean, David?
It means it's not about them. It's about the person for whom the funds are saved and are being managed. You don't have to have an economics degree to be a trustee. You know, you don't have to know how to invest in stocks and bonds and that sort of thing. You just have to be honest and have the recipient's best interest at heart, and try to do what the parent would have done had they been alive.
Yeah. So we've talked about powers of attorney. We've talked about guardians and custodians and trustees. We haven't talked a lot about executors yet, Colin. And everybody thinks about, as you said, they sometimes even get confused about power of attorney, executor. Talk about what is the executor's role in all of this.
Yeah, so the executor, also a fiduciary, is basically the person who will, when you pass away, they're named in your will. And there's also kind of the synonymous term with that as a personal representative or an administrator. And that kind of depends on whether you die with or without a will. If you die with a will and you name somebody in your will to take care of your estate, that's your executor. If you die Without a will, then the person who takes care of your stuff is your administrator, but they all kind of fall under the umbrella term of personal representative. So your executor, hopefully, will pretty much do an inventory of everything that you do own and then kind of follow the directions for your will as far as who they're going to distribute those things to. And it sounds pretty easy, and it's not too difficult, but it's all kind of monitored by the clerk of court. Essentially, they're going to be the person who gets possession of your stuff, maintains your assets, and then eventually distributes them to who they are directed to go to.
One of the ways it's just helpful for me to think about it, because I'm a little simple-minded, but I think about a bucket, and that estate is, or your estate is a bucket. Your executor's job is to grab all of your stuff and put it in the bucket. And then he goes and looks at your will, or if you don't have a will, he looks at the statute, or she, and says, okay, what am I supposed to do with this stuff? And then they start taking the stuff back out of the bucket and giving it to whoever. And when the estate is all done, the bucket's empty, and we close the estate.
And of course, the bills have to be paid first.
Yeah, that's right.
Before any distribution.
Yeah.
And there have to be a creditor's notice placed in the paper so that if the deceased owed money, then they need to contact the person, the executor that's handling the estate, or the law firm that's handling the estate. And the bills have to be paid first by law.
Yeah. And one of the things that we talked about in another podcast was 1% interest, in ways that, and if when we're talking about trust, these are ways that you can avoid this whole probate process. And as David alluded to in another podcast, probate's painful.
Yeah.
Probate is painful. And if we can avoid that, that's the best of all worlds. Yeah. And there's ways that we can avoid that. Colin has ways, David has ways. There's things that we can do to prepare for that moment that would make it so much easier on your families if we could just avoid that probate, and frankly, less expensive.
And you can imagine, and many of us have experienced the pain of losing a loved one, and I guess everybody has, but you need, as a father, as a grandfather, I would want my children, my wife, my grandchildren to have the easiest time possible handling my estate. And the way to do that is to pre-plan it so that they can, if they need a power of attorney for me, it's there. If they need and the person that I want to be the power of attorney is there. If I need a healthcare power of attorney because I'm incompetent, it's there. And then at my death, they're going to know who my baseball cards go to. And they're going to say, what did Daddy want to do with his baseball cards? Well, it's right there.
Yeah. That's the way. So we've talked about powers of attorney, both healthcare and durable, or general, and then we've talked about a will. We haven't talked about an advance directive or a living will. So in my thoughts, that's probably one of the least important of the documents that we're talking about. Just talk a little bit about that and what you guys think as far as, is that something someone should have, and what does it do?
I generally tell my clients about it. Usually it is the least important, but I keep using the wayward son from California. If you've got some family dynamics, such as a blended family sometimes that may have some unusual dynamics, or a second or subsequent spouse, and then children by prior marriage. And the living will just says that I don't want my life prolonged by artificial means should my death be imminent, and should I die from this injury or this illness that I've got. And the key is, should my death be imminent. We're all going to die sometime, we know that. But our deaths are not imminent as far as we know. But sometimes death is imminent, and we know it. I know the living will was so helpful in my grandmother's situation and in my mother's situation. For example, in my grandmother's situation, it helped my mother make a really hard decision about her mother. But she was able to do it because her mother had a living will that said, I do not want my life prolonged by artificial hydration or artificial nutrition if death is imminent. And so it made it so much easier for my mom. But you can imagine if my mom had a brother from California saying, no, don't do that. And then you've got a poor doctor standing
in the middle.
There. What do I do?
Yeah.
Well, so
Mom's already said, here it is in black and white.
Here it is in black and white. It's legal. The North Carolina legislature has a suggested language to use. The law of North Carolina has said through the years this language is appropriate, and the doctor cannot be held liable if the doctor follows the directives of the healthcare power of attorney and the person that has given a healthcare a living will. I'm
Yeah,
sorry.
sure.
And so the living will and the healthcare power of attorney relieve the doctors and the nurses of any liability, the healthcare providers of any liability by law,
Sure.
if they follow those things.
Well, one of the things that we see in all four of these documents, in this day and age, it's just where we are. Inevitably, someone has passed away. We have somebody walk into the office, Colin, excuse me, and they hand you a document, and you look at it and you think, I don't know where this came from. And you ask them, where did you get this? And they say, well, I printed it off the internet.
Yeah.
Talk to us just a little bit about some of the things that you see from the estate administration side with documents printed off the internet that could be a problem.
Yeah, it's those documents that you get off the internet I don't know who's drafting them up or what's going on with them, but I think they advertise themselves out to be kind of the silver bullet of estate planning, the one-stop shop. I've seen some crazy things as far as documents all being merged into one. It's got a living will heading with the power of attorney language with a testamentary direction at the bottom of them. It's kind of a Frankenstein of all the documents we're talking about here, and the long and short of it is a lot of times it doesn't work. It seems easy, and it's kind of going back to the age-old thing that if it's too good to be true, it probably is. So that's what I'll say is that, yeah, you can find a lot of documents purporting to be a lot of things online, but it's really rolling the dice as far as whether that's going to be something that's going to achieve your goal.
As a lawyer, I want to remind everybody of an old Fram oil filter commercial where a man in a black T-shirt held up a Fram oil filter and said, "See me now or see me later." And that's the way it is with lawyers and estates. You are much more likely to have litigation if you try to do it yourself. And that I've seen it over and over and over. People try to draw up their own wills, whether they use something off the internet, something they got out of the library, or something they just made up. And it's highly probable that they're going to end up in litigation. It may not be witnessed correctly. For example, a power of attorney has to be notarized, whereas a healthcare power of attorney has to have two witnesses plus a notary. The witnesses cannot be healthcare providers, and the will, you can have a holiographic will where you do your own will in your own handwriting and it's found with your other important documents. Don't do that. You're gonna have your heirs and your family seeing me or Colin or Luke and saying, "What does this mean?" And so,
And oftentimes we're going to say, well, I don't know. We're going to have to ask the judge what it
right,
means.
and the judge has to rule what it means.
Yeah.
And to go to a judge, you got to pay lawyers, and usually there's two sides on it.
Yeah.
And then you got double payment of lawyers, and it's just not worth it. So come see us and or some other attorney and get some help with these things.
This applies in every area of law,
Yeah.
whether it's family law, whether it's criminal law, whether it's real estate, estate planning. If you come see us early,
Yeah.
before you do the documents, before you sign your name, it's so much easier for us to help and to avoid the problems. My dad used to have this thing that he would say that a poor man can't afford anything but the best because he can only do it once.
Mm-hmm.
You know, if you're trying to scrape by and you think, oh, I just can't afford an attorney. Well, when it comes to these important documents, you can't afford not to have an attorney. And I'm not saying it has to be one of us. Just go to an attorney to get your documents drafted. There's a lot of good estate planning attorneys out there. Colin's one of them. David has done how many estates? I mean, there's
It's too many to count.
yeah. So I mean, come see us, and we can help with these things, and it will save you so much headache, so much heartache, and so much money in the future to come see an attorney now. Yeah, it's going to probably be more expensive than the documents you get offline, but you're actually going to get what you pay for. Mm-hmm. I had a business coach when I was doing heating and air work who used to tell me that, you know, you've heard that you don't get what you don't pay for, or you get what you pay for. He said, well, that's not true, because sometimes you pay for something like a will off the internet, and maybe it'll work, maybe it won't. So you may not get what you pay for, but you don't get what you don't pay for. And so it might cost you a little bit more money to go to an attorney, but you're going to get what you pay for.
And if it doesn't work, it's too late.
That's right.
Yeah.
You can't change it.
Once mom or dad's gone.
And same thing with the healthcare power of attorney. If it doesn't work, that person's incompetent to sign any other documents.
Yeah.
And if it's a will, that they're deceased, and
Yeah.
you're stuck with what it is.
We're literally talking about life and death.
Yeah.
And it's just not something to try to save money on. I tell our staff all the time in the real estate department that what we do is no less important than what doctors do, because we're dealing with people, especially in real estate. If you're talking about family law or criminal law, you're dealing with people's lives and livelihoods. And so when it comes to that, it's important to have professionals involved.
I've had 6 years ago, I had surgery for cancer, and I'm cancer-free now. But I can tell you that my mom's death and my dad's death were a lot more stressful and painful to me than anything related to my cancer.
Yeah.
And it really was.
Yeah. So guys, come see us early. Come see us now. If it doesn't matter if you're 18 or older, come see us. We need to start talking about this, especially if you have small children. Please, please, please get your estate plan in order. Do it now. It's not fun to think about. None of us want to think about it. None of us want to imagine that day, but it's coming and we have to plan for it. So not wanting to think about it doesn't stop it.
Yeah.
No, it's still coming. So don't forget, like and subscribe to our YouTube channel. Watch us on Facebook. Hey, we're here to help. So give us a call. Come see these guys and get that will, power of attorney, healthcare power of attorney done. We'll take care of you. Thank you so much for watching.
The information contained in this video and audio recording is general in nature and should not be relied upon in making legal decisions. Every situation is different, and you should consult with your attorney before making any legal decisions.